Employer retaliation has to do with when an employee engages in what we like to call protected conduct. And basically what that means is the employee has to bring up certain things to their employer in order to be protected under the retaliation statutes. So an example that I like to give for what is protected conduct for retaliation is if I go to my boss and say, hey, you know what? You're treating so-and-so differently because of his race, and I think that you should stop that. That would be considered protected conduct. If I went to my employer, a manager for instance, and I said, you know what, your accounting practices, they're really kind of illegal, I think. I really don't think what we're doing here is right under the law. That would be considered protected conduct. So if my employer then retaliated against me by demoting me under suspicious circumstances right after I made that report of, say, racial discrimination on behalf of another employee or on behalf of myself, you know, that could be a retaliation case. If my employer terminated my employment right after or shortly after saying, I think you're doing something illegal, that would be a retaliation case. But it's not retaliation to say, you know, to your employer just in general, boy, you know what, my workload's just a little too much here. I don't like what's going on. Or, you know, John down the hallway isn't really doing his job and there's no consequences. So not every instance of you bringing up an issue to an employer is protected conduct that would then, you know, protect you under the retaliation statutes.